Here, there is another role of court. A party can approach the court post completion of the arbitral process. Here, that award is given. Once that award is given, there is a doctrine which is called functus officio. In the perspective of the arbitrator, his role is officially over. Functus official. Officially, his function is over. And if that function is over, then there is no such concept of reopening. Many of practically initial stages when this act was enacted, there were parties, predominantly respondents, in the cases where they are losing. They will come to the same arbitrator and they'll say that, oh, kindly reopen. We have the practice. Even I, as a lawyer, we had the notion that, okay, fine, we have this reopen. The common order 8, rule 8, all these components, we try to bring CPC, but we can't do it. This particular provision, which gives a role of court, gives an exclusive authority to the court to look into, particularly the setting aside application of that award on certain grounds. There are 7 grounds, no doubt. The 7 grounds, out of 7 grounds, 5 is procedural and 2 are quite legal principles. The only ground what the party has to be much worried, or the arbitrator has to be worried, is if the award is against the public policy of India. As a lawyer, I always use this particular ground to make our cases numbered, and successfully we will also end up in setting aside the arbitral award on major issues, when most of the arbitral tribunal are presided by non-legal persons. This is what is happening, unfortunate, but still there is an opportunity, but that opportunity is given only to the courts, not to the parties or the arbitrate tribunal. The challenge of setting aside of an arbitral award can be done only by the courts, not by the arbitrators. And the final constructive role, there are many more roles of court, but these are the actual one where the courts assess the arbitral proceedings. That is section 37. This particular provision gives us opportunity to make challenge before the courts, which is not stopping the arbitral proceedings, on 5 counts. The first count, if the court is not referring the matter to arbitration, even though there is an arbitration clause. Second, if the court is granting or refusing to grant some interim measures under section 9. Third, the arbitral tribunal is granting or refusing to grant interim measures under section 17. Fourth, the arbitral tribunal is accepting a plea of jurisdictional challenge and saying that I or we have no authority to continue with this arbitration. In such a situation, that order is appealable under 37, which is order given based on section 16. And the fifth one, setting aside or upholding an arbitral award under section 34. 5 orders. In that, section 7 is an order given by court. Section 9, an order given by court. Section 16, an order given by arbitral tribunal rejecting the plea. Section 17, an order given by the arbitral tribunal, and section 34 given by the courts. Or in all these appeals, which is given under 37, appealable orders. No way it is stopping the arbitration. It is facilitating the arbitration. It is saying that you can proceed with the arbitration. If you are not in a position to proceed, then the court is coming and the court is looking into, oh, fine, the court has, the earlier court under Section 8 is not referring the matter. We can look into what is the reason for it. And later there is possibility in the appeal to send the matter to arbitration. These provisions, which is given under these provisions like 8, 9, 17, 8, 9, 27, 34 and 37, which has constructive role of court, which gives the arbitration proceedings a tooth. It pushed the arbitration provisions. It is not an impediment or a hindrance to the arbitration proceedings. Before 1996, the 1940 Arbitration Act, which was a major legislation in our country before independence, which was facilitating arbitration, at every stage of the arbitration proceedings, there were court intervention wherein it goes to the court and the proceedings get stopped. Now, the 1996 Act is very clear. The proceedings can't stop. Very drastic situation, there might be some court orders which might stop, but looking into each and every provision, we can't find not even one slight subclause or subsection highlighting that we can stop the arbitration proceedings as such. The only situation, if the arbitrator is not in a situation to proceed further and he is not taking a decision at that time, the court can come and rescue the parties to continue the arbitration by substituting that arbitrator, removing and substituting. Otherwise, the role of courts is really constructive. It's not destructive. And this judicial intervention doesn't stop here. These are the major one. It also adds with a component called default role. If the parties are not using their choice of appointing the arbitrator or they are not mutually agreeing, then the court, the High Court for domestic arbitration and the Supreme Court for international arbitration comes into rescue and appoint arbitrators. Further, when you look into these appointment of arbitrators, the court has multiple say. And here in this situation, we do come across many cases. I think Mr. Johnson would have already circulated multiple, as he rightly pointed out. NN Global is there. There are many cases which has given a clear picture of what is party autonomy and what is the role of courts. Few to highlight. One is the Bharat Aluminium Company versus Kaiser Aluminium. Balco, B-A-L-C-O, Balco, Bharat Aluminium Company versus Kaiser, K-A-I-S-E-R, Kaiser Aluminium case. It was reported in 2016 SEC Online, SC 83. If you see in this case, the agreement states that the law applicable and governing the arbitration should be English arbitration law. And the judgment lets that it was held that that the agreement as a whole would be governed by Indian law and the arbitration alone will be governed by English law. They are bifurcated. Actually, the terms of contract will have to be understood in the way what the parties wanted and intended them to be, particularly the agreement to arbitrate where the party autonomy is supreme. That was the observation in that particular judgment. I'll requote it. The terms of the contract will have to be understood in the way the parties wanted and intended them to be, particularly in agreements of arbitration where the party autonomy is supreme. The parties agreed and mentioned the word English arbitration law, and it was interpreted in the way the parties took and dragged away in multiple proceedings, and the court finally held that the agreement as a whole, that the contract as a whole, shall be governed by the substantive law of India, and the arbitration alone would be governed by the English law of arbitration, that is Arbitration Act 1996 of England. The arbitration was happening outside the country. Some clarity was given. Here, in this case, the word court mentioned, the party autonomy is supreme when it comes to agreement of arbitration, that is arbitration agreement. Similarly, there are multiple judgments. Some which I wanted to highlight is, another one is PASL Wind Solution. PASL Wind Solution Private Limited versus GE Power Conversion. GE Power Conversion. This also, I think, 2021 SEC Online SC 331. Here also, the Apex Court has observed that as party autonomy is going to be the guiding spirit of arbitration, the parties are free to agree on the application of the major components, that is the laws to be applicable, like law governing the entire contract, as well as the resolution of the dispute by arbitration. One thing we have to keep in mind, when it comes to the applicability of substantive law or the governing law for our arbitration, the contract which has the arbitration clause, if both parties are Indian, the governing law has to be India. It can't be outside. And if you have one party coming from foreign or incorporated outside, then the governing law or the substantive law can change. But in this judgment, PASL, they have accepted the spirit of arbitration to be party autonomy. So much significance is given. It also continues in some cases like Siddhi, SIDDHI, Siddhi Real Estate Developers versus Metro Cash and Carry India. Metro Cash, Siddhi, SIDDHI, Siddhi Real Estate Developers versus Metro Cash and Carry India. I think it's a Bombay judgment, wherein it was highlighted that, or it can be observed, autonomy of the parties should be preserved by the court as far as possible. These are all judgments facilitating party autonomy. And it also observed that the parties should defer to the court. Sorry, the court has to defer to the appointing procedures which the parties have agreed. The court shouldn't intervene too much, and it is left to the parties what they wanted, the intention of the parties, and same time retaining the discretion to appointment such arbitrators would also deem to be meeting the end of justice. These are some judgments which facilitated the party autonomy. But there was one judgment, very recent. Many of us obviously use it to challenge the unilateral arbitration clauses, which is Perkins Eastman Architects, PERKINS, Perkins Eastman Architects versus HSCC. In India, the party autonomy was taken to the extent that most of the arbitration clauses, particularly where the public sector undertaking or the whether the federal government or the state governments are involved, as parties to commercial contracts, there will be a condition that government entity or the department shall have the authority to appoint a sole arbitrator. And in some cases, like dealing with Navaratna companies, like oil companies, ONGC, IOCL, BPCL, HPCL, in all the contracts, it will be mentioned the chairman of that particular organization shall appoint the general manager projects of Oil India as sole arbitrator. This was a very common practice from the inceptions of those arbitration clauses in those contracts. That was creating a huge issue, and many judgments are saying that it is a sovereign role. The state is involved. If the state is involved, the state shouldn't end up in some issues, taking some issues outside the court. They wanted to have a unilateral condition, an acceptable one. This judgment came as a challenging point for party autonomy. The party autonomy is there, very well safeguarded. It has to be safeguarded, but still it is leading to a bad practice, an unacceptable practice of giving authority or entrusting an authority to one party in the dispute to appoint. It has to be party's autonomy. It can't be party autonomy. And they strike down, and in this particular judgment, the Apex Court mentioned it clearly that if an arbitrator is appointed by one party and one party acting as the appointing authority, then that appointment or even the outcome of that arbitration, that is the award given by that such a sole arbitrator, has to be set aside prima facie. And in the same judgment, they have mentioned that one person who is the interested party shouldn't have an exclusive right to appoint. And if he is not going to have that authority to appoint, he can't appoint his person to be acting as an arbitrator, or the same person who is ineligible to be having the authority to appoint, he can't act, as well as he can't appoint a person to act as an arbitrator. Very detailed judgment, similar to NN Global. NN Global is very recent. It is this judgment happened to be before the pandemic, and this has given a safeguard measure, and it is facilitating the party's autonomy to go in a way which it has to be, that is bilateral. These are some interesting development what we are coming across when we are involving in parties' autonomy and role of courts. The courts are there to assist. The parties are given the fullest freedom to determine whether to go to arbitration, if they are going to arbitration, who the arbitrators are to be, how they are going to be appointed, what is be the procedure, when to stop, when not to stop, what has to be done on the pleadings, what has to be done on the time frame, and also they can go for an amicable settlement even before an award is given. Post award, if an award is given, later also the aspect of acceptance also is there evident as a party autonomy, and all these makes us to go for arbitration, particularly advise the parties to enter into arbitration agreement or the arbitration clauses, which is very much necessary in this commercial world after the major revolution in the practice of what you can say, the implementation of globalization, privatization, whether it is in a jurisdiction where the political situation is different or not. Arbitration is quite common. Arbitration is considered to be similar to courts, and arbitration courts are evident in communist societies. It is also available in capitalist society. It is also acceptable in democratic society. Every society, every ideology accept this arbitration for the very purpose of having this dual composition. One, party autonomy, and another, the constructive role of courts. These are some points I wanted to share with all of you. And these points have to be seriously considered, taken into consideration when you are advising your parties or when you are representing your parties, as well as when you are going to preside as an arbitrator in an arbitration proceedings.